All right. Good morning, everybody. I'm going to go ahead and call to order the Texas Behavioral Health Executive Council meeting. It is May 18th at 10 a.m. and we'll begin with the roll. Gloria Fonseca, the chair, is not here. Mr. Brumley, not here. Dr. Cartwright?
Here.
Thank you. Mr. Francis?
Happily present.
Very good. Mr. Halbauer?
Here.
Ms. Rogers? Ms. Smith?
I'm here.
Very good. Dr. Taylor?
Ready to go.
Very good. And John Belamowitz, I'm present here, so we do have a quorum. So thank you, everybody, for being here.
Mr. Chair, before we go on, just to make sure we cover our bases there, we probably need a motion to excuse Gloria and Brian's absence since both of them are going to be absent from the meeting today. If we could just
Very
do
good.
that real quick.
Is there a motion?
Mr. Belamowitz, I would like to make a motion to excuse the absence of our members today, please.
And second?
Second.
Second.
Been moved and seconded, and without objection, they are excused. Thank you very much for that housekeeping, Mr. Spinks. So I'm going to go ahead and start with the. We're gonna do a couple things out of order here. Let's go ahead and start. I'm going to start with the chair's report, and then we'll go into public comment. This is probably the most sad and most difficult chair's report that I've ever been asked to give, but I'm going to go ahead and give it my best here. Most of you guys already know, but for those who don't, the council recently has lost one of our own. Christina Lamone and her son on April 22nd were killed at their home. Horrified and shocked. There are probably not strong enough words for the feelings around here, and for those who work with her closely. So I don't know what else to say about that. I've tried to get that into words, but it really kind of escapes me. But everybody here has been horrified and shocked at that. To those who worked with her closely, universally, she has been described as one of the kindest, most hardworking, conscientious people that they have had the opportunity to work with. And as our public information officer, those are really important qualities. As a public information officer, that's the person who ensures that there's open governance. In terms of if somebody wants something in accountability, it had to go through her. And so those are some of the best adjectives, frankly, for somebody on the team that does that job that could be described with. Again, in talking with the staff, she is universally missed. And you can tell that she has left her mark on this agency, that she helped stand up. She's been with the BHEC since its inception and at the Psychology Board before. For her family and friends that she leaves behind, they are all in our prayers. And while obviously we don't hurt the same way that they do, we don't hurt alone. And we all are hurting with her absence and the mark that she left here. Christina was a dedicated public servant. And again, the qualities that she has been described with for the role that she had cannot be understated. She made a mark here, and we will miss her. Her and her son Xavier were laid to rest last week. There was a flag flown over the Capitol for her family that was presented here by agency staff. And we just want to note and appreciate them, the family, and she was very proud of her daughter Alicia, who's a student at UT, who she leaves behind, and her especially are in our prayers as well. We're going to observe a moment of silence for a moment, and if you care to join me in silent prayer for that moment as well, we'll do that right now. Thank you very much. With that, we'll go
John?
ahead. Yes, ma'am.
Before we go on, if there is a fund set up for her children, or if there is any kind of a fund set up, would you let the members of the board know so that we can help contribute to that? I would like to do that if there is some sort of a fund set up, please.
Absolutely. And thank you for asking. Absolutely. We'll do that. Okay. With that, we're gonna go ahead and get into public comment, and then we'll get on with the rest of the meeting.
Okay, let me get my head in gear here.
Take a minute.
Yeah. Okay, ladies and gentlemen, we're going to go ahead and take public comment out of order this morning. Tip on the agenda, it's listed towards the bottom, but it, as stated in the agenda, we can move things around. We want to make sure we give everybody an opportunity to give public comment before we take up any big items under the topic number 4, which is action items or under the rules. So if you have public comment that you'd like to give, I need you to go ahead and use the raise hand function so that we can identify you. And if there are any callers that are calling in, once I've gone through the people with their hands raised, I will then unmute the callers and you can give public comment as well. And for the callers, if there are any, just when it comes time to unmute yourself, it'll be *6. So go ahead and raise your hand if you'd like to give public comment. Right now, I'm not seeing any hands raised. Okay. Okay, here we go. Dr. Sarter. Dr. Sarter, you have public comments you'd like to give?
Yes, sir, Mr. Spinks. I hope everybody is doing well this morning. And so let me start by saying good morning. My name is Dr. Terry Ann Sarter, and I'm a licensed professional counselor supervisor, counselor educator, and the liaison to BHEC for the Texas Counseling Association. Additionally, I am thankful for the opportunity to serve on the BHEC Rules and Standardization Task Force. TCA supports and agrees with the new language proposed in 801.43C2 of the Texas State Board of Examiners of Licensed Marriage and Family Therapists Board Rules that mirrors the Texas State Board of Examiners of Licensed Professional Counselors rules. The consistency of the language pertains to LPC and LMFT associates, and it will be useful for the public and for professionals who are pursuing dual licensure. In reference to the proposed changes to the continuing education requirement in 681.140F and J, the language does not include a requirement for providers to maintain certain types of records. As a result of BHEC no longer approving specific providers and the council allowing 50% of continuing education to be gained from providers not covered under 681.140F, then at minimum, a list of standards that CE providers must follow should be included. TCA encourages BHEC to consider including a standard that this continuing education must be delivered by a fully licensed mental health professional or attorney. Additionally, in 681.140J, professionals are required to maintain their continuing education records for a period of 3 years. TCA encourages the council to require CE providers to maintain their records for the same 3-year time period, to include a record of attendance and the delivery of curriculum. These modifications would further protect the public and mental health professionals seeking continuing education that is directly related to professional mental health services. We appreciate and respect your hard work and the hard work of the volunteer boards. Thank you for listening, and we appreciate your time, efforts, and dedication.
Thank you, Dr. Sarter. And just for the record, for the folks that have submitted any kind of written public comment in accordance with the instructions in the agenda, just so that you know, those comments have been submitted to the council members for review, so that they have gotten those. I don't want y'all thinking that we've overlooked that. All right, next up is going to be Mr. Will Francis with NASW. Will, did you have public comment you want to give?
I am. I appreciate the seriousness of the meeting this morning, and thank you so much, Sheriff Blumenwitz, for your comments. To reflect the matter at hand, I would just like to share that We'd like to just comment on the rules that are up for you all on 781.401. The proposed amendment removes a requirement that supervised experience must be obtained within 5 years immediately preceding the date of application. I'd just like to stress how important this is for such a wide variety of social workers who are either reapplying because a license has lapsed or have previous hours that have come in, and just stress our appreciation for this particular rule and how much we appreciate y'all's consideration for it and how much we do support this rule. So thank you for that opportunity today.
And I'm sorry, which number were you saying in support of specifically?
So specifically 781.401, which removes the 5-year cap on when supervision hours can be submitted.
Thank you. I just wanted to mark it down.
Okay. Thank you, Mr. Francis. All right. Are there any other individuals that would like, members of the public that would like to give public comment? If so, I need you to raise your hand now. Kind of a speak now or forever hold your peace. Here we go. Mr. Gomez, do you have public comments you'd like to give? Mr. Ruben Gomez?
Yes, can you hear me?
Yes, sir.
Okay, thank you. Yes, I just wanted to, Ruben Gomez, LPC supervisor, liaison from the TASIS organization to the BHEC board. And I wanted to echo Dr. Sarter's comments regarding CE requirements, that there be standardized requirements there for fully licensed professionals or attorneys qualified to give the CEs, having the maintenance of attendance, the curriculum delivered, some form of record of attendance, and keeping those records for the 3-year period. And just wanted to kind of reinforce kind of what she was stating about that.
Okay. Was there anything else, Mr. Gomez?
That's good. Thank you.
Okay, thank you, sir. All right, one last call. Anybody else? Any other public comments? And I'm not seeing any telephone. Nobody's calling in today. So that's all I'm seeing, Mr. Chair.
And there's no members of the public here.
Correct.
Okay.
All right. Thank you to everybody with your comments, thoughtful comments. We appreciate that. And I think we'll get into 3. Mr. Spinks, do you want to take us away there?
Sure. I'm gonna, you've noticed that I've kind of restructured the agenda for this meeting. I'm trying a different format that I hope will make it easier for everybody to work through. Topic number 3 or agenda item 3 are all informational only. They are topics that I don't anticipate requiring any kind of discussion or action on the council's part. Obviously, you always have the option to do that. So I'm going to kind of go through these rather quickly because they've been presented to you for review. And unless you have a question, I'm not going to spend a lot of time on it. Under 3A, the second quarter performance measures, they speak for themselves. We're headed in the right direction is all I can tell you there. We're actually doing good. And then of course, 3B is our year-to-date financial reports. That's where we give you the monthly budget reports that Jenny, Ms. Noack creates for us. 3C is really where I wanted to stop and mention one thing. When you look at the average licensing processing times, you'll see for the MFTs, April wasn't a good month for us on the MFTs. I don't worry too much, and I don't want y'all to worry too much about the MFT exam eligibility because that's the legacy process for approving applicants to sit for the exam. That thing's going to go away. It's a dying animal or a dying breed. So I don't want people worrying about that. Historically, it had taken a long time to do. And now we're just seeing some that are really old that are finally coming through. That's not a delay or a problem on the agencies. That number is not indicative of a problem at the agency. We've just had some old applications that are being approved. But that'll eventually go away, just like what you see on social work exam eligibility. The only other number that really caught my attention when we were looking at this, and I use this chart as a way to keep track on just how we're doing. I don't really do it so much with a mind or an eye towards the council. I do it more of a way for me to keep track of what, how we're doing. Are there any problems that are developing? And the only one that really caught my eye was the supervisor. It jumped way up from 10.78 to 137. Part of that problem, there were two in there that were two applications for supervisory status that were our fault that we had overlooked. And then there were three in there that the applicants themselves had just not taken any action on in a long, long time. And when you get such few, when you have so few that actually do it, it doesn't take much to skew the numbers. So that's why that figure is up high. We had two that sat a little longer than what they should have due to our actions or our inaction. And then we had three that sat too long due to the applicants not kind of taking the action that was needed to move it along. So, but I've looked at that, we've got that rectified, the problem that was on our end. So we're, I don't anticipate those numbers to continue forward, going forward. So, Mr. Francis?
I did have a question in regards to the budget.
Okay.
I noticed that we're doing great with it. So thank you very much for that. We're currently at 51% spend we have 49% left with 34% of the year remaining. So we're well ahead. What do you attribute that to? Because when I looked at it, is that because we just haven't had people on board and so we aren't spending the salaries that we normally would spend at this point, or what's happening there, please?
A lot of that is unspent salaries. When you got vacant positions, given the fact that salaries make up the largest component of your budget, outside of like the database, but salaries make up the largest component. And we've got three, I think we've got 5 or 6 vacancies in the licensing division, 1 in enforcement. So you're talking about a pretty significant chunk of money there that is not being used. And that's where it's coming from.
Okay. Are there things that, do you anticipate that will come under budget to this same degree at the end of the year? Or do you see greater expenditures or unexpected expenditures that'll happen on the last quarter, last third of the year?
I think probably when agencies move up in size from, say, well, like what all of us were pre-BHEC, we were all we're still technically considered a small agency, but we're much larger than what SIPE was with 14 FTEs. Once you move out of that really small agency status up into our size, you're always going to have a certain number of positions vacant, which means you should always have an excess budget at the end of the year, that unspent salary. Whether it's going to look like this every year, I don't know. Because honestly, what we're going to have to do is take a look at this, and it may be a year or two. We may have to get a year or two under our belt, but we may want to take and look at reallocating those FTE positions. Like right now, I've got 3 temporary receptionist positions that we cannot fill. I've got a couple of 2 or 3 admin positions. We need the admin, so I don't want to reallocate them, but like the temporary, what if we needed like an assistant general counsel? We could consolidate those 3 FTEs into 1 and use that salary for the assistant general counsel. So I don't want to paint the picture that is money that we can reallocate to different parts of the budget. In other words, postage, mailing, travel, all that. But it may not always be excess funding laying around like what you're seeing here. We've got some adaptability where we can reallocate that money and create a new position, if you will, if we're seeing a shortfall, if we've got too much workload in one position. Does that answer your question?
It does. And let me get to my point. I apologize. And as John has taught me, let me be careful with my words because I don't want to seem like I am advocating for spending money to spend money, the government's tax funds just for the spend of it. But the question I really have is, are there things that we can do for the team, knowing that we will probably have some excess funds left over that are needed, that we're not necessarily budgeted for, that would either help in our efficiencies or help in expediting licenses, or that would help in terms of equipment or automation? Are there things that we can start to think about now so that at the last month, we're not stressing about anything along these lines?
Yes. That's a good question. And here's how I've kind of done it in the past and how I'm doing it now. You you always hope that you have a pot of money left over at the end of the year. And I know I remember hearing my dad gripe about when he was in corporate America. He would come home and he's like, yeah, they're making us spend all this money at the end of the year. And I'm like, well, why? Why don't they just save it? I kind of get where they're coming from on that now. What I typically do is I try to look and see what big IT projects, what are our big IT needs as we start to approach the end of a fiscal year? What are our training needs? That's something that we need to focus on in the strategic plan. That's an area that I've identified in the strat plan where we need to focus is training the staff we have to make sure that they recognize they're valued and so on. But you can use that funds to do merit salary increases for, high performing staff. You can also use it for merit bonuses. So really it's money that can be used for any of those purposes. And that's something that we look at. I mean, just by way of example, one thing I had to do, I guess it was about a month ago, we're part of the Health Professions Council. And so one of the things we were about to lose the administrator for the Health Professions Council. He was actually took a job over at SORM, and they were paying him considerably more than what the Health Professions Council was paying. Basically, he's the ED for HPC, the Health Professions Council. And so BHEC, along with 3 or 4 other agencies, we chipped in enough money to make sure we could keep him because he is integral. I mean, he's key, very important to making sure that our shared regulatory database continues to run smoothly. And so that's that's how I use that money whenever I see a need. That was kind of an unusual need because I'm paying it to HPC. That'll be an ongoing charge, but we use it for staff merit increases, merit bonuses, IT purchases. If we want to do any kind of switch over to some sort of cloud-based workflow system, that's where we could look at using that money for, conduct any kind of studies that we would need to do, that it can be used for that. So say we wanted to conduct a workflow study, have somebody come in and review our workflow process with outside eyes, fresh eyes. That's something we could do with that funding there. You're right, though, George, in that you've got to do that. You want to do that well in advance of the end of the year because you can't, there's a law that says you can't pay forward. In other words, if I'm going to buy a service in the future, I can't go ahead and pay for it now with this year's funding if it's going to be a service that I'm buying in the next fiscal year and the next biennium. So we got to be real careful, and you got to be kind of thoughtful about how you prioritize the tasks you want to do. But these are things we think about. This is what Jenny and I meet very regularly about okay, what are our needs? What do we think we're going to be needing? What are the problems we're seeing right now? What are the possible solutions? How are other agencies handling it? And then we start exploring what does it cost to do it. So that we're constantly doing that.
So I'm just one voice, and from the things that you listed and from what I was thinking about, I think the performance of the agency this year has been incredibly productive. I think we've shown improvement. The value is there. And so obviously number one in my world would be bonuses, only because a merit increase, unfortunately, is something that would continue into the budget of next year, and you have to plan for it every year thereafter. But bonuses are something definitely that would be able to do. The second thing, though, that I would kind of like to see is what are some of the recommendations of things that we can do to improve the efficiency of the organization going forward? Are there acquisitions or things, even consulting, I don't know, whatever it is that you might recommend that you can bring to this board that we can look at doing to help the citizens of the great state of Texas, as they often say on our council, on our board, that can be brought forth that we can look at as options. That's all I had on this. That's just why I want to call that out. But thank you for the time and for allowing me to discuss that.
You bet. And that's something I've never been too shy about bringing ideas back to the council. I mean, the social work, when we switched over the social work program from our doing it in-house to moving it over to ASWB, that's an example of kind of how we look at things and try to problem solve. I mean, I'll just tell you off the top of my head what I want to do. I don't want to sound too assertive here, but I want to see us move to like a online CE broker type system where we can move our continuing education submissions. People upload it, they can see what they're short, what they have, if they meet the requirements. I want to move that online. I don't think that'll end up costing the agency anything. I also want to look at some workflow processes that I think will help resolve some of the anxiety people have whenever they go, well, I submitted my application. What's the status of it? Kind of a ticket system, if you will. There are so many of those out there, and I've just kind of started scratching the surface on it as I have time. But that's going to be a direction I think we're going to move eventually. I know those are pretty pricey though. That's the only problem there.
And obviously I have an inherent bias of moving anything and everything to the cloud, but I don't think that your labor shortage and your ability to hire quickly is going to change anytime soon. So those things that can be automated and those manual tasks that can be removed, I think those are things that we should really focus on and look at. How do we change our process to get off of the manual labor drug? Because that's what's going to help both the agency and the citizens in the long run. So that's where I would try to figure out how can we apply funding to that. But thank you.
I completely agree with the labor problem, and we're not getting to hire people in exactly a cheap part of Texas. We're hiring people for downtown Austin, and that's not going to get any cheaper anytime soon, I don't think.
We will definitely. I know Jenny, Tim, and we're constantly looking at that thing. So we'll definitely kind of start putting a little more pressing in that direction a little bit more. So I agree. I like it. I like moving towards the cloud, to be honest with you.
Aaron, what ability do we have to hire remote workers?
Oh, we can. The part of the problem, like on enforcement, our enforcement staff are almost 100% remote. I mean, they do come in, every so often to collect files, and they take them home, work on them, but they're coming in maybe once a week. A few people, the problem you get into is some people don't like to work from home. And then you have people like me where I cannot work from, I do not have a home office, and I've got 2 little kids running around. I can't get anything done when I'm there. So I have to come in. So you've got those kinds of things, but I will tell you, the vast majority of our staff are working remotely, at least on a rotating basis.
I just mean in response to John's point about downtown Austin. It is expensive to live there, obviously, and work there. So are we able to hire people that live in rural counties or live in other parts of the state that would never come into the office?
Yes. I mean, the short answer to your question is yes. It becomes a little more difficult I would hate to have an investigator in El Paso and then have to mail stuff, and trust those complaints and all that information going through the mail, because we've had some bad experiences with that.
Well, I mean, to George's point, though, I mean, we just get it in the cloud, just get secure.
Well, that's true. Yeah, right. That's true.
Let's join the 21st century.
Yeah, that's true. And I mean, this is also something that Representative Franks had discussed. He and I had discussed this at one point about kind of just some of the problems of when you locate all the agencies in Austin, you're all fishing from the same pond, and you just make the competition. It's just a higher competition there. So, anyway, that's something we have talked about before. So we'll keep moving along. All right. Anything else on the budget? Okay. The next item that I just wanted to bring up is the enforcement report. You guys, the public can see the Q2 enforcement report. I've also given board members, council members, y'all have the mid report for Q3. I wanted to show you kind of where we are. I mean, things are continuing to improve. I will tell you that Patrick and I and Alfonso, we've talked. Our goal is we are going to push hard and heavy to have all 2015 through 2019 cases gone. or at least docketed over at SOA by the end of this fiscal year. We've got to get those cleared. They have just got to go. We've got to get them resolved and get them off the books. It's way too long. That they need to go. So no one understand that we are making a concerted push on 2015 through 2019 to get those cleared and off. And I think we're down to 20 something. The mid report that y'all have, I don't even think it's accurate anymore. I think it's already outdated. The numbers are lower than what you see on that mid report. So the next report you see, it ought to be much more favorable. But I will say I'm noticing an uptick in the number of agreed orders I'm signing. I think that's probably due to now that we've got, we brought on a couple of new attorneys, staff attorneys, and they've got their legs under them now. And you can really tell once everybody starts clicking, because the number of agreed orders in my box start ticking upward. So, but I think we're in good shape. Really, overall, we're in good shape there. The newsletter, I'm not going to go over too much. The only reason I included that ASPP newsletter is to show you how many people are in SIPAC, how many people are participating. It's got, I don't know, 3,000, 4,000, 5,000 people in SIPAC. That's 4,000 or 5,000 more people that can deliver services in Texas without them living here and drinking our water and, driving up housing prices and all the other fun stuff that goes on. So that's kind of a win-win there. Certification from our audit. We had a good audit. I don't have it. I mean, obviously the auditor found some things that we needed to make changes, and we're going to make those changes. Y'all are going to vote on them here this meeting. And but we had a good audit, and I was very pleased with the outcome. The auditor, she was awesome to work with. So I mean, she really helped us kind of nail down where the problem areas were, and they did a really good job in that. I've worked with auditors in the past, and they just tell you, you stink in this area, and then they're gone. You never hear from them again. This one actually took time to go, here's some examples of what a good one looks like. And they kind of helped me massage the language to make sure it kind of meets muster, if you will. Next item is I just put in there an update on our request for an AG opinion. There's no update to give, haven't heard anything, so don't have anything to report back on you. I included there 10 legislative policy trends that I think you can probably expect to see going forward. Again, I'm not going to spend any time on that. It kind of speaks for itself. Then I've got, of course, Governor Abbott's February 22nd letter that dealt with child abuse and Paxton's opinion on that. And then, of course, I've given you the agents. Y'all have seen the stock response that I have for when people email us or write us about that. Nothing's changed there. The SCOTUS Supreme Court Texas did hand down a mandamus order that I've included in your materials. It's a pretty interesting read, I guess, if you're a legal geek like me. It's an interesting read. If not, it'll put you to sleep. The state health plan, I'll let you guys read that on your own. That is actually a pretty interesting document if you want to know about numbers, kind of projections on where we're going, the states of your own professions in the state. That'll give you a good idea of who's growing, who's contracting, what's the demand look like. I've given you some information on our move to the Capitol complex. We're set to move on June 10th, assuming the freight elevators are back up. Now, the public hasn't heard this, but we're scheduled to move into the Bush building on June 10th, and we got word yesterday that the freight elevators are down. They're already broken. So we're not.
Hey, there goes the budget surplus. It's all going. It's all going to the freight elevator.
Exactly. So I'm not sure what's going to happen there. Nobody said that we're off schedule, so we're looking to be in there June 10th. This should be the last meeting, other than, well, I guess Psych Board's got a meeting tomorrow. The last meeting we have in the Hobby building. Hopefully, the next time you see us, it'll be from a bright, shiny new state office building at 1801 Congress. Shortly thereafter, we should have meeting rooms to begin resuming in-person meetings if y'all so choose. So the conference rooms, there's some glitches with them, so don't expect it in June or July to be able to have them, but I do expect it this year for y'all to be able to resume in-person meetings. There was one little glitch I'll tell you about. We were talking about money earlier. These things pop up. We had to pay $5,000 to have some sort of internet cabling run from the bottom of the building up to the 7th floor. I never, that was just one of those deals where it's, you get the bill and they're like, oh yeah, we forgot to tell you, you won't have any connectivity if you don't pay this $5,000. So we can stretch this cable from the ground to the 7th floor. So didn't have much choice there. Telecommuting policy, I don't need y'all to approve that. I've done that kind of under my own authority. That is a policy that I put together based on medical board, dental board, my own research, my own proclivities on what I thought was appropriate. I feel like we're in pretty good shape on that. It gives us the flexibility I think we need. We've got the interim charges. There's a pretty important report in there on classified employee turnover. That's 3Q. The most striking thing there is that the statewide turnover rate was 21.5%, which is very high. That's a very high turnover rate. BHEX was 21.1%, not much lower than the statewide average. My goal through the strategic plan is to get that, I want to get that down to 10% or lower. Point being is we got to retain staff because once you lose them, you can't replace them. It's too difficult to replace them. And you know, so that's what we need. I think that's what we're going to need to focus on. But anyway, there's your that report for your review. Also, just a heads up, I was invited by the they're not invited, but they'd mentioned it. The Council of State Governments. I'm working with them on drafting the social work licensing compact, and they had brought it to my attention that the NCSL, the National Conference of State Legislatures, is having a conference in Vegas on antitrust concerns and activities for state regulators. So I'm going to go to that in June. I wondered why. I thought, you know, the hotel rates are pretty reasonable. The flights are pretty reasonable until somebody said, well, have you ever been to Vegas in June? And I'm like, no, I never have. And so that, I may regret it, but so I'm going to go out there.
Take your sunscreen.
Yeah, pack your shorts, pack your moisture wicking.
So I'm going to go out there for that. It's just a 1.5-day conference. So I'll be out there and back real quick. They pay for everything. That's the good thing. By virtue of our membership in the Council of State Governments, that's covered. So it doesn't actually cost the state anything. The next item I want to talk about, and this one along with the Brokamp case, this is one where George, did you have your hand up?
I did. It was for a previous item, but you're on a flow and I didn't want to interrupt you. I did have a question about the telecommuting policy.
Mm-hmm.
In reading through it, there were two things that really struck me as kind of strange. One is the ability for a manager to go and inspect the facility or the work location of an employee. So if that employee is working out of their house, then the manager can do that. Is that common at the state?
It's in other telecommuting policies now. Whether anybody actually utilizes it, I don't think anybody ever does. I think the concern there is if somebody is at home and they're working, you know, are you going to have do you have the setup to do this, or what you're really doing is running a daycare out of your house while also, you know, working for the state? Like if you showed up at my house, it would look like I was running a daycare while also being the ED. Y'all would not approve of my setup. I sat at the kitchen table. It's just not good. So honestly, we haven't had any concerns about that with staff, and we've certainly never used that, but that's what it's designed for.
And I know this humanistic approach is not my normal side, but isn't the deliverable the most important thing? I mean, wouldn't you be able to tell by their deliverables of what they're producing and their work quality versus their location quality? I mean, ultimately, what you care about is what they deliver, not where they're delivering it from or the situation around how they're delivering it.
True. But if you're trying to rectify the problem, if you're trying to work with them to rectify the problem and they're telling you one thing and what you're doing isn't working, there may be some other factor in there. And if it is an environmental cause rather than some sort of your asset that you are not providing them with in order that allows them to be successful, you know, to me, that's why it's important to have it in there.
Okay. And then the last question, what I didn't see in there, and I might have just missed it in my reading of it, Does your policy allow people to work from any location or any place? So if somebody wanted to relocate to Hawaii for 4 months and work from there, can they do that?
You can within the state. You can do a temporary relocation. What we won't do is allow people to work on a permanent basis outside of the state. And the reason for that is we don't want to get implicated in New York or California's workforce laws, their human resources laws.
Right, but for like 3 or 4 months, can one of the employees go and?
Yes, you could. Yes.
Good, very cool.
Yeah, say you wanted to go to Corpus and rent a house down there for for the summer. Yes, you could do that if it was approved by your manager. Yeah.
Thank you.
The next items are the two cases.
I think, Janine, do you have your?
Oh, I'm sorry.
Do you have your hand up?
I do, but we can wait till the very end because it's a question based. It's still within the 3 informational items, but my question was on the Texas update to the state health plan. Who actually made up the bodies that put this plan out? Because I didn't see that. I saw it was the State Health Coordinating Council. Who's in that? Who did this?
I don't know who those. I think they are appointed. I think those members are appointed. I don't know how that occurs though, Janine, to be honest with you.
Okay, because I just want to know, where did they get some of the figures that they came up with, or these recommendations? How did they come? How did this get delivered to us? Is
Yeah.
the rationale I was asking. Okay.
Yeah. I want to say HPC is on that. There's a state health coordinating council, and then there's a state behavioral health coordinating council.
Yeah, it didn't have any information in that. When
Yeah.
it said the roster down there, it doesn't include who are the people that actually put this together. So I was just curious what bodies made up this report.
Yeah. Hey, Brenda, remind me to send Janine links to those two, the state health council and then the state behavioral health council. I've got links to their website saved because I go to them from time to time looking for this stuff. I'll send that to you. And I think they probably describe the makeup and who selects those participants.
Okay, thanks.
The next cases I want to talk about, or the last things I want to talk about, are the two cases here. The Smile Direct Club versus Brocamp. Before I get into that, we finally received what we call a previous determination letter from the Attorney General. You'll see under 3T. It doesn't mean anything to y'all. It's a big thing for Patrick because when people do public information requests for complaint information, we don't constantly then have to go get an AG opinion that they can't, that is not accessible through public information. Now we could just point to the previous determination and say, you're not entitled to that. It's illegal to give it to you. So that's an important thing. Yes, sir.
Daryl, quick question on that. I looked at it pretty closely because it arose out of an LPC matter. Are the circumstances behind it pretty rare? And that's why we didn't have a procedure in place for how it was going to be addressed?
No, what happens is you all had a previous determination letter when you were at HHSC. We had one, all the boards had one. And then when we moved into BHEC, it's a new agency. And so we didn't that didn't carry over to BHEC. We made the argument. How many times did you ask for it, Patrick?
Too many to count. They repealed the statutes that those previous determinations relied on and recodified them in Chapter 507 as a brand new statute. So we had to get a new previous determination like we had before so that we could then rely on that.
We asked well over 10 times for a previous determination letter, and each time Patrick just added added to the previous request to the list, and it got pretty long. I guess they got tired of hearing from us and finally gave us one. But
so this was a situation where somebody asked about a disciplinary action but was not a party to the action?
Correct.
Okay. So this will be the official policy moving forward now that we have this confirmation?
Well, it's statutory. We can't provide that stuff. It's not even really a policy. What this does is it says we don't have to go ask the AG to confirm that we cannot give this information to them. We can just point to this letter and go, we don't have to we can't give it to you. See the previous determination letter.
Okay, and it doesn't require any rule changes on our part. We're good?
No changes. Yes, we're good.
Okay, thanks.
So the Smile Direct Club and the Brocamp case. Let me cover Brocamp first, because we'll start with the good news and I'll end on the bad note. Brocamp is a case where we've got an LPC in Virginia who is suing the District of Columbia, the LPC board in the District of Columbia, saying, hey, I want to provide telehealth services in your jurisdiction. And DC said, no, you can't. You're not licensed here, so you can't do it. She sued. And the reason this case is important is, and I put the minutes from the district judge's hearing in there. The reason it's important is the standard that the judge applied. I really thought when this case, and I remember Mr. Francis asking me, he goes, what's your gut opinion on this? What do you think is going to happen? I remember thinking, well, I think probably ultimately the district will prevail. Well, I don't think that anymore after reading these minutes. And the reason being is the district judge seems to be applying what we call strict scrutiny to the district's laws. Almost nothing survives strict scrutiny review. It's the highest level of review that a government regulation would have to clear in order to remain on the books. So my concern is going forward, if this thing pans out the way it kind of looks like it's going, I think probably DC is going to lose the case. Now it will then go up to the 11th, or I guess the DC Circuit Court, and they'll have to, the DC Appellate Court, they'll have to decide, and ultimately it may end up at the Supreme Court. I don't know. But my point being is this is not headed in the right direction if you're a regulatory body, because if it goes and the law of the land is now, well, as long as you're licensed in one jurisdiction, you can practice in another. It's kind of like, well, why do we do compacts? Why do we do all this other stuff? It's just once you're licensed, you can telecommute into another jurisdiction. So it's a big deal. This is a big deal. This case is, and we need to be watching it. And it's still in the early phases. I don't want to, I'm not trying to freak everybody out too much, but everybody needs to be watching it. Dr. Taylor.
Carol, is the licensee using the argument that the argument that because he's licensed, is it West Virginia?
Virginia.
In Virginia, and that he is providing services in Virginia? Is that his argument, that because they're telecommuting into Virginia, he's providing the services in Virginia?
No, the argument seems to be it's more of a First Amendment argument in that you are restricting speech, and it's not a it's a what do we call a content-based, I guess it's the content-based, it's just a free speech restriction. And when you do that, the district judge is saying, in order to do that, DC, you got to pass strict scrutiny. So that it's not depending upon where the provider is versus where the patient or the client is. It's a speech argument.
Well, that's unfortunate. That's less exciting.
I'm curious as a non-lawyer, but in terms of interstate commerce, is there not an interstate commerce angle on this as well, where the feds could regulate something, and also maybe even the full faith and credit clause? Does that have any relevance here?
I don't know.
I'm just curious if you saw that in the arguments anywhere.
I hadn't really thought of that, to be honest with you.
Okay.
Dr. Cartwright?
I thought it was interesting too, just in the terminology of counseling versus professional counseling, how they could kind of change the parameters of what that means within that jurisdiction. So I thought that was really interesting and something to watch, just basic terminology and basic verbiage of the wording they're using for that particular service. And then you get into, like, again, life coaches and, self-help folks and all kinds of other areas that can kind of bleed into what is counseling versus what is professional counseling. So I thought it was just it's a very interesting case. I read the whole thing and thought it was something to watch for sure.
Yeah. It's gonna be a brave new world if that keeps going in the same direction. The next case is the Smile Direct Club case. Now, this is one, this is one, it caught my attention because this involves an ED and an investigator in addition to the board members. The short version is Smile Direct, they offer teledental services. They can somehow or another, I don't know, I'm not going to go into all that, but it's a teledental telehealth case. And long story short, California has said, hey, you can't do that in California. You're not licensed here. And Smile Direct has sued the California Dental Board for that and some what they allege to be some harassing behavior. And this is all done under the Sherman and the Clayton Acts, which is the federal antitrust laws that I'm always harping about. I know y'all are probably sick of hearing about from me. But there's a provision in those laws that says thou shalt not commit a conspiracy to engage in any kind of antitrust or any competitive behavior. And what Smile Direct is alleged here is that there is a conspiracy between the board members and the agency staff to engage in anti-competitive conduct. And while this case is in its early beginnings, it was just what we call kind of like a 12B6 motion, which is very, very early on. The Ninth Circuit has said, no, individual board members can conspire with agency staff and therefore be in violation of the Sherman and Clayton Act. We're not saying that these folks have done that, but as a matter of law, we're saying that that is possible under the Sherman and Clayton Acts. And it doesn't matter that what the board members and the agency staff were doing was allowed under state law. If it violates federal law, it's a no-no. And what really brought this to my attention was, one, it was the ED. And I've said before that I'm kind of on the hook with you guys if we do something wrong, that I can be on the hook with you. But I had never seen staff sued in their individual capacity before. And this one really caught my attention because I'm like, ooh, that's what I've always said could happen. I've never seen it happen. Now it's happened. I've seen board members be sued in their individual capacity. That happened at the Texas Medical Board. So that happened very close to home. But here we've got California board members. And the thing of it is the plaintiff didn't sue every board member. They picked the ones that were really kind of pushing the issue. They left some of the board members who weren't part of the conspiracy alone, and then they went after the ones that were. And some of those were public members. Most of them were dentists. Most of them were the licensed professional members, but they went after a couple of the public members as well, instead of just suing the whole board. So the only reason I bring this up is I know y'all and the public, y'all probably get sick and tired of hearing me talk about anti-competitive this and anti-competitive that. This is just a real world example, guys. We aren't in the world of theory and academia here. I mean, this is the real thing, and it can happen. And we've got to be on our toes whenever we're looking at this stuff, because I don't want to find myself in that ED spot. If the facts turn out to be half as bad as what they have alleged, they're all in a lot of trouble out there. But time will tell. But anyway, I'm just bringing that to your attention to show you that, look, it can happen. Staff can get sued right along with you. So I just want us to make sure we're all working together to make sure that doesn't happen as best we can. So
one of my big takeaways from this is when we talk about doing anything that, I mean, as a regulator, as a regulatory board, we do restrain trade. That's what we do. There are barriers to entry. The question is why? And the barriers that we have are for the safety of the public, to make sure there's a standard of care, and that when somebody says that they're a psychologist or a counselor or a social worker, that they're competent and ready to provide those services. When we do want to put a restraint of something on something, something I ask is, well, why? And where's the data? And why is this necessary? Because when we can hang our hat on the data of why this is necessary, whatever action we're taking, we're in great shape. But when we get out over our skis beyond that, then you find this is where California finds themselves right now, kind of in uncharted territory. Why were they trying to restrain Smile Direct Club? Like, for what purpose? Was there data there? that says that their restraint's gonna hold water.
That's pretty much all I have, Mr. Chair. Ms. Francis, I thought of one other thing in response to your question about, you were asking about the issue in our telecommute policy about inspecting the home. Patrick and I had something come up, and I remember this is another reason we had that language in there. Patrick and we were attending a conference that the Attorney General puts on every year.
Okay.
And one of the issues that came up was, what happens if somebody gets hurt while working from home? Is that going to be a workers' comp claim for the agency? Honestly, I don't know the answer to that. And I don't think anybody at that conference knew the answer to that. And I'm not trying to put anybody on the spot here, but do you know? I mean, y'all are bound to have a bunch of people working from home.
If the company's policy is to allow them to work from home and they are injured during the normal course of their activities in employment, it will be a workers' comp complaint. Yes.
Lovely.
Right. Same.
Okay.
Gotta clean those toys off the floor, Daryl.
Exactly. Jenny's not going to approve a workers' comp claim from me. I can just tell you right there. I'll have to bleed out on the floor.
Daryl can't work from home anyway, so
That's right.
we're good.
Yeah. Now, Daryl, to be clear though, that does not extend outside of their normal duties, right? So if they take a break or clock out or something and then hurt themselves or get hurt by something, then we're no longer liable for that.
Right. Okay.
It's funny you should say that, because we actually, not in my group, but there was someone who fell down their stairs going to get lunch. And so it was outside of them producing product. And because of that, it was not, but that actually happened. So
Yeah.
That was the analogy. That was the hypothetical that they gave us at the conference. They were like, what happens if somebody, trips over the door while they're going to get lunch in the kitchen? Is that, and I'm like, I don't know. I don't want to be the person that makes that law, makes the law books there. That's all I have, Mr. Chair, for number 3. That'll take us into number 4.
We've been going for an hour. We want to take a 5-minute break real quick, standardies, and come back in 5 minutes. Come back at 11:05. All right, without objection, standardies until 11:05. All right, it is 11:05 by my clock right here, and we're coming back into session. I want to come back real quick before we go into 4. I just want to reiterate one thing on that last point on the Smile Direct Club. When I got onto the board originally, on the psychology board, we were sued, and we were named individually, but we were named in our professional capacity. So it was simply we got served with the lawsuit as well, essentially at our home or business or wherever they sent it. The difference with this one is it's individually and their official capacity. And individually, they're talking about suing them personally. So the only things that escape that if they lose are essentially your home, a car, a limited amount of stocks or retirement or something else. But everything else is on the table. Your business, your livelihood, that's all on the chopping block. So I just wanted to make that distinction because sometimes when you're just named individually versus being sued individually personally, that's a key distinction to make, and they're getting sued individually personally as well. So I just wanted to reiterate that and before we got on. So without anything else on that, we're going to move on to 4 action items. Gerald, you're leading this discussion, correct?
Yes, I will. There's nothing to review on 4A. I just put that in there as a placeholder in case something pops up after the agenda is posted. We can then go ahead and take it up without holding it over to the next meeting, but there's nothing to cover under A. B is the strategic plan. I will tell y'all what you've got there. You've got the strategic plan. I did not include the appendices that go with it. And I just apologize for that. I just have not had time to do them. I'm working on them now. There are things like our hub report, customer service report, which y'all have already seen, strategic workforce planning, and then I forget there's performance measure definitions, which is really something Jenny does. Honestly, those appendices are just numbers compilations. It's not anything that we can edit or you really have any kind of artistic creativity over. It's just, these are the numbers. They are what they are. So that's why I wasn't as concerned about it going forward today, but I do need the strategic plan itself approved. so that I can get that filed on June 1st.
Do we have a motion?
Mr. Chair, I make a motion to accept that, please.
Been moved by Mr. Francis, seconded by Ms. Smith. All opposed, signify by saying aye.
Aye.
All in favor?
All opposed, say no.
John, I think you asked for all opposed first.
Yeah. I did. I'm sorry. All in favor. I'm sorry. Excuse me. All in favor, say aye.
I
All
thought it was
opposed,
a
say
trick
no.
question, John.
Just want to see how many of us were listening. I know him.
Thank you very much. Motion carries.
The next item is the personnel manual. I need that approved as well. That's the product of our TWC audit. That's what I worked on with the auditor to develop.
Is there a motion?
Mr. Chair, I make a motion to approve the manual.
Move to accept. Your second. It's been seconded by Ms. Smith. All in favor, signify by saying aye.
Aye.
All
Aye.
opposed, say no. Thank you very much. Motion carries.
Then the next item is the fiscal year 2022 workforce analysis recruitment plan and annual report. I need that approved as well as a component of our audit.
Motion to accept.
Mr. Chair, I move that we accept the workforce analysis recruitment plan and annual report.
Second.
A second.
It's moved and seconded. All in favor, signify by saying aye.
Aye.
Opposed, say no. Motion carries. Daryl, I think I'm going to take this next one. Is that and we're going to have to actually potentially go into executive session for the next one. And so I'm going to hold that one back until the end, so we don't make those members of the public do the musical chairs of in meeting out of the meeting or make them wait. So we're going to take that one at the end of it.
Okay, and then the next item is going to be the 4F, which is the review and approval of the executive leadership succession plan.
Mr. Chair, I make a motion to review, for the approval of the executive leadership succession plan.
Perfect. Do we need a discussion on this, Daryl, or is there anything you'd like to highlight about this before we go to?
I can tell you how I developed it. One of the things this is really kind of a codification of what we've been doing in practice for quite some time now. I know BHEC isn't that old, but I don't mind saying that what I had always envisioned and planned for, if I get hit by a bus, you're going to need somebody to sit in my chair. And I've kind of been, I'll just say it for lack of better words, I've kind of been training and grooming Mr. Hyde to be the one to do that in the event something happens. From a very practical standpoint, it's going to take 3 or 4 individuals. If I go down, something happens to me, Patrick's going to have to stand in. It's going to take Ms. Nowak handling the financial side. Mr. Spear is going to be handling kind of the daily operations of the agency. And then of course, Ms. Giff is going to be the steady hand and whoever sits in the chair. So what this does is this document tries to encompass all of that to make sure that you guys are covered if something happens to me. I'll tell you the one weakness in the plan, and I do not know how to get around this, and that is the ability to kind of read the political winds and judge the politics of a situation. That I don't know what to do about that. I don't know how to plan for, that kind of a void in the leadership role. That being said, I probably don't need to, because we're talking about a temporary situation until you guys can get somebody hired to fill my spot if something happens to me. So, but I just wanted to point out that is the one weakness that I haven't been able to figure out how to account for. But I feel like the leadership team that we've identified in the plan, that they can get you through. I promise you they can get you through. You've got a very competent team that can stand in and fill in the gap if something happens to me.
I also think too, as board members, I mean, reading political tea leaves and making sure that there's dialogue with the legislature when necessary. There's a lot I think that we can do as board members to facilitate that. Not even just in your absence, there's a lot that we can do in that, as we sit. So that's something I think that consider in our roles as board members, something that we're capable of doing, and something that if something did happen to Gerald, that we would probably be really needed to do. So without further discussion, go ahead, sorry.
Sorry, quick question. Daryl, as this is going to be an annual review, is there any sort of deadline on it, or we're just going to pick it up during one of the meetings every year?
You just do it with my review, with the ED's review every year.
Okay.
That seems to be the most appropriate time. I borrowed that timing chain or that timing trigger from another agency. What I did is when I started developing this, I sent a message out to all my counterparts at other agencies. I said, show me what your plans look like. Most of them don't look, this is pretty comprehensive compared to what I was provided by most other agencies. A lot of the other agencies don't go into this level of detail as to their succession planning. So, but I'm trying to, I know how scary it is to sit in the chair for the first time, and I wanted to make it I wanted to try to reduce that fear as much as possible for whoever has to do it if something happens to me, by identifying the big ticket items that you're going to have to cover.
Okay.
Good deal. So there's a motion on the floor by Mr. Francis to accept this. Is there a second?
A second.
And it's been seconded by Dr. Cartwright. All those in favor signify by saying aye.
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 Any opposed, say no. Thank you very much. Thank you, Mr. Spinks, for working on this. I know this was discussion, and we, standing up this agency and getting us going, it would be a tragedy to not have something like this in place to protect the good work that we've already done here.
And Chair John, I would just add that it's a good sign of a good leader that plans for their absence and plans for someone to replace them. And it's a great sign of how the organization is run, that the whole thought is that there's somebody who can step in, and that it's a plan and schedule change. It's an orderly change. And so I commend you for doing that. And I commend what I saw in the document. So thank you for that.
Thank you.
The other, I wholeheartedly agree. But also here, it sounds like there's active development happening and growing the talent that we have. Obviously, I hope to retain as much talent here at this agency as we can. But the reality is if we're growing and farming talent, and again, we want to keep it. If these the good that we're doing here spreads to other agencies of government, then pat ourselves on the back for that, for growing that talent. So again, thank you, Mr. Spinks, for putting this together.
Patrick objected strenuously, but too bad. I haven't got hit by the bus yet, so I get to issue the order.
Sounds good. Yeah, you got to watch out for that sidewalk out front. There's no sidewalk there. I was like 2 feet from the bus getting it. So you got to watch out. Okay. Where are we? I lost my place. Daryl, are you still going?
On number 5, we're done with 4.
Oh, okay, rulemaking. There we go.
Yeah.
All right, thank you very much. Do you want to lay out the executive council fees here?
Sure.
885.1.
If y'all will remember at the last meeting, we talked about the fee reduction and how to address that. Some of the concerns being, look, if we do this, are we going to get a call from the LBB, the comptroller, or somebody down the road saying, look, we're now short $3 million in revenue based off your revised fee schedule. So, we'd like you to revisit that issue. So what we did is we built a rule that adopts a fee reduction, but it makes it effective on September 1st of 2023. That will give the interested parties, and I won't go into who all that is here, but that'll give the interested parties an opportunity to see how this change affects our revenue. And then if there is any pushback, we still have an opportunity to change it back without jerking the rug out from under it. In other words, nobody will be paying the reduced fees, and then all of a sudden we take it away and the fees go back up. So it gives us the time to do it.
And not only that, this is a proposal. This is not adoption of this. This is putting it out to the light of day for everyone to see, comment, review, discuss, throw rocks at, or support.
Correct. It's just starting the rulemaking process here. We're going to propose it. I didn't want to, when at the last meeting, y'all were like, okay, this is what we want to do, but I didn't want to just, at that time, I didn't have the rule crafted. I was really just trying to see what y'all wanted, take your temperature on it. And y'all said, okay, we want to do it with a delayed effective date. So here is the rule. Here's how Patrick and I crafted it to try to give effect to what our orders were. I think, I feel like it captures what y'all wanted. It's just, do we still, you still have to make the call. Do you still want to propose it?
I think the other thing to just get out there, this is old news to a lot of people, but just for the edification of the public in terms of how this works, like we don't get, in terms of the fees that are collected, it doesn't go into the VHEC piggy bank. It goes to the general fund and the legislature decides how much of that we get back.
Correct.
And in this case, I'm gonna speak out of turn here. Money goes up to the general fund and they give us back less. And this would be a reduction in what we are giving to them up the food chain, which if every agency did this, the legislature has to figure out where revenue is coming from, essentially. Am I stating that accurately?
That's accurate. That's correct.
So that's the mechanics of how the money flows. There obviously politically has been a push to reduce fees. I pay occupation licensing fees as well, and I don't like paying them. So yeah, if there's an opportunity for us to reduce them, something we ought to look at. And there's a lot of work that went into this to get these down to this level. So yeah, we can put it out there and see if we can get it done. Any other discussion?
Dr. Cartwright?
I just have a question. I was just curious what sort of analysis is done to determine the different fees for the different separate boards? Is there an analysis that how you come up with that number to kind of fit into the budget? Or is it just kind of, the fees have stayed relatively stable over the years from what I've gathered, and renewal fees, but I'm just kind of curious, is there more that goes into the psychology licensing than I just noticed the fees are a lot higher on the psych board too. So I was just curious, more or less a question of how you come up with those numbers and maybe potentially why the psych numbers are higher.
Wasn't it generally like a holdover from, we just took all the other fees, we started with the fees from all the original boards prior to the foundation of BHEC, and they just all kind of stayed the same. And that's sort of how the budget was done, was it not, Daryl?
Yeah, we carried over a lot. Now there were some that went up, and some went up, some went down, some we did away with. I can't remember all of them. I know on social work, some of the social work went up. Their fees did. I can't remember. I know psych stayed the same. I can't remember about LPCs or MFTs though. It's been so long ago. It's roughly what came over. Psych is almost exactly what came over.
Right.
Those fees are. But the other boards are pretty close to what came over from HHSC. How they were arrived at, I couldn't even tell you how psychs were arrived at, all those years ago, because that was long before I came there. I can tell you how we arrived at the figures in the reduced fees. I can speak to that. We said, okay, we're going to set the fees at the lesser of what we're currently charging or 75% of the national average. That's how we came up with those numbers in the revised or the reduced fee schedule.
Makes sense. I was just curious because I just was looking at the numbers and always wondered how, if there was an analysis done that came up with that number to make it fit within budget. Obviously, there's a lot more LPC licenses out there. So it's just, I didn't know what factors played into into those numbers, but was just curious how it came up with it.
The biggest overall factor, and it's not so much that you look at the program, it's you look at what it costs to run the agency. And then you have to figure out, okay, what do we need to charge for, renewals here, renewals there. The problem is, when we created BHEC, we were coming in with kind of set expectations. Everybody already knew, well, this is what I've been paying for renewals for X number of years, or apps for X number, so we kind of had to work with that. We really weren't starting with a fresh slate where we could just go, everybody, you're going to pay the same renewal fee. You couldn't do that really. We talked about that, but I don't even remember now the rationale why it didn't I remember we shied away from that discussion pretty early on in BHEC's days. And we opted to kind of stay where we were. But shortly after that, then we struck upon the idea of, hey, let's create the fee review advisory committee, get all the stakeholders from all the associations in here. That way they've got some input in this. And then we went to work on trying to figure out how to come to some sort of an agreement on what those fees would be. The problem is anytime you reduce one fee, you oftentimes have to increase another fee to offset it. So that was that's an internal struggle and debate you have to have. So.
I remember that conversation in terms of when we're trying, like, I mean, the one size fits all approach got shot down really quickly because it is a zero-sum game. And if somebody's winning, somebody's losing at their expense. And there's a whole lot of different boards and licensees here. So that was pretty obvious pretty quickly from, I remember that conversation. It was not going to be tenable. All right, so we need if there's not further discussion, we need a motion to propose this.
Mr. Chair, I make a motion to propose.
And move to propose. Is there a second?
I'll second.
Seconded by Ms. Smith. All in favor signify by saying aye.
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 Any opposed, say no. All right, the ayes have it. Motion carries. We're going to propose this. Thank you very much. And I know a lot of work went into this, so thanks to all the stakeholders and input that went into getting us this far.
Okay, and there are no rules for adoption under BHEC. The next one is going to be the Mft Board Rules, and we are looking at 801.2, 801.43, 801.302, and 801.305. The only one that I figured probably Janine or George will lay out these rules. The only one I'd like to speak on a little bit is at 305, just because it's procedurally, there's some trickiness to it. You want me to go ahead, Janine, George? Okay. On 305, that is the schedule of sanctions. And you'll notice kind of a theme as we go through these rules. The schedule of sanctions are moving more towards a grid-based system that's very easy to apply when you're at SOA or when you're trying to figure out what the sanction for conduct is. Previously, a lot of the boards had used a more of a descriptive type schedule of sanction where they wrote out what the rule was and then the punishment. We're all moving towards the grid or the chart form now. Previously, in the MFT board had proposed some changes to this same rule that were published in the April 22nd edition of the Texas Register. Now the MFT board has said, hey, we want to move over to the chart-based system. Well, rather than letting that first rule go all the way through the proposed process, which will delay what they've sent up to the council today, what we're recommending is let's pull down what was previously published. We'll incorporate all the changes into one rule and then send it on up. So that's what we're recommending here. So that we don't have to wait on one rule to go all the way through that process before we can even begin the new recommendations that the board just sent up. So that's the trick. It's a repeal and replace type deal.
And so to restate that, we're proposing for the first time, the first three on the agenda, and then for the fourth, it will be a repeal and replace.
Yeah, you're going to withdraw the previously proposed version and replace it with this proposed version.
Gotcha.
And if you need it laid out for the first three, the 801.2, that's just a clarity piece to this amendment. It just clarifies what direct services, clinical services are. The next one, the 801.43, this is to, pardon me, this is to help for, excuse me, pardon me. This is a representational piece. We have so many dual licenses with LPCs and LMFTs. Those are probably the most dual licensed. We have some psychologists with LMFT as well, but most of them are LPC, LMFT. And this just makes it to where both licenses are being represented in the same way. Just helps for clarity for people who are seeking dual licensure. And all it is that LPC associates have always had to say who they were supervised by on all their lines, and LMFT associates have not. So this is requiring the LMFT associate now to also place that who they're supervised with while they're under supervision. And finally, 801.301. This is just a clarifying rule. It's to combine two of the level 1, level 2, level 3, level 4, or 5, just to combine levels 2 and 3 into one. So instead of 5 levels, there's 4 levels now for sanctions. And that's what those 3 are intended to do. Do you guys have any questions for any of the first 3?
Thank you.
Any further discussion or questions? Okay, I guess for the sake of efficiency here, if it's not contentious, sounds like I'd entertain a motion to propose the first 3 and then on 801.305 to withdraw the version that was sent up on or published on April 22nd and re-propose with this new form.
Mr. Chair, as a proud member of the MFT, I would like to make a motion to accept the top 3, and then we'll come back with a second motion.
Okay, it's been moved to propose 801.2, 801.43, 801.302. Is there a second?
A second.
Seconded. All in favor signify by saying aye.
Aye.
All opposed say no. The ayes have it. Motion carries. So we'll propose those first 3 and then.
Mr. Chair, I'd like to make a motion on 801.35 to repeal and replace. Recommend withdrawing of the version published in April 22nd and repurposed with this new version.
Okay, so it's the motion is to on 801.305. Is there a second?
I'll second.
It's been seconded by Ms. Smith. If there's no discussion, all in favor signify by saying aye.
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 And opposed say no. The ayes have it. Thank you very much. Thanks for the work that went into that as well.
Thank you to this board for accepting them.
It's done.
And that's it for the MFT board, Mr. Chair. We don't have any rules for consideration for adoption. Moving on, the next one is going to be the psychology board, rules for psych board. We've only got 2 under the proposal. And I'll say right now, the 470.1, we need to, that one, we don't need to take up. After further review by staff, there was some confusion and we don't need to make that change. So I'm recommending that the council not propose that rule. There was just some confusion there and that change does not need to take place.
You said that was, which number was that?
470.1.
Thank you.
The next rule, the only rule that does need to be proposed is the 463.35. I would point out there's a typo in that rule in the rule number. It's correct on the agenda. We've got it listed as 463.35. In the rule, it's 465.35. That's not right. It should be 463.35. It's not a substantive problem, so we can just change that. That's not going to be a big deal. But I just wanted to point that typo out.
Sorry, the correct one is on the agenda.
Yes.
Correct.
Okay, the correct one is 463.35. Yeah, I'm looking at that typo there as well. Perfect.
Harold, did you want to talk about subsection D2 or D1, sorry, as well?
Refresh my, is this the where we're adding the language that the MFT board?
The non-substantive change?
Yeah, okay, yes. Okay, so when the MFT board, they were the first ones to move forward with the new standardized CE rule. And so when we ran it up to the governor's office, the governor, actually one of the MFT board members had requested this change be put in. And then when I think it was maybe the social work board or something, we sent a similar rule up to the governor's office and they were like, hey, we think D1 needs to be clarified so that it doesn't conflict with A3 or something like that. A2, I think. Yeah, A2, which was the exact same thing the MFT board had said to do. So this is just as a matter to head off the governor saying, hey, y'all need to make the same change to this rule that you did for the MFTs and the social work side. So that's why I'm putting it. It's a non-substantive change. It doesn't change anything about it. It just clarifies it so that the governor's office won't come back and point out the same problem.
And also just to point out as a non-substantive change that avoids us sending it back to the psychology board we can go ahead and proceed
Yeah.
with that. This.
And I got to give Dr. Elder credit. She's not here to say, I told you so. I argued against this. I was like, we don't need that. It's the more specific controls over the general. And so, but I lost that debate. And the governor was like, yeah, she's right. You're wrong. So,
Kudos to admitting it.
so Dr. Elder, if you're out there, I just admitted it publicly.
You never hear the end of it now.
I know it.
I'll entertain a motion to propose this.
I'll second.
Okay, you gonna make the motion? You go ahead and make the motion. Moved by Dr. Cartwright.
Second.
And seconded by Mr. Francis. All in favor of again 463-35, signify by saying aye.
Aye.
Any opposed, say no. Thank you very much.
And I'll make a move to repeal 463, or the proposed repeal of, is that 463-35, or is that? It's the
It's repeal and replace.
repeal.
Yeah, we're repealing the old one and proposing this new one in its stead.
I'll make a motion to repeal.
Second.
Okay. And all in favor, signify by saying aye.
Aye.
Any opposed, say no. Thank you. All right. We have no adoption for psychology, moving
Correct.
For the LPC board.
This is the only one where it's going to get a little bit tricky procedurally how we go. We probably need to first take a look at 681.140, the very first rule in the list, and decide whether we want to move forward with proposing it or sending it back to the LPC board for further review and discussion. And the reason I say that is, if you'll remember, most of those public comments we got, well, virtually all of them except for one, dealt with this rule. So with that, I'll turn it over to Chair Hallbauer, Dr. Taylor.
Yeah, Daryl, that was the first thing I was going to bring up. We did receive a lot of written public comments regarding 140. The main thing that was repeatedly brought up is that they feel as though the rule as proposed is taking out independent stakeholders as a CE provider. Can we discuss that a little bit? Because I know that we are not in the business of really giving our stamp of endorsement to any of to CE providers, and I feel like the rule as proposed, we're starting to do that. We're talking about an approved list, and we're talking about, well, this group is fine, but that group is not fine. And you know, I've listened to the comments on this. I've read them. I have concerns on my end, and so I did want to discuss it a little bit today. And Dr. Taylor, did you want to add on to that?
No, just to echo what you just said, Chair Hallbauer, I think the general concern from our licensing base is it cuts out a large number of people that are providing CEs and very high quality CE programs from the total count. And so I think there's just a little confusion with that. So we definitely want to reevaluate it. And I know every time we make an adjustment to CEs, there's a lot of anxiety around it. I think it's a very important part of our profession, obviously, and one that we should take seriously. As the four of us try to come together and figure this out with some kind of standardization.
So I had a quick question, Dr. Taylor and Chair. Because I've read a lot of the negatives to this rule, so I just want to make sure I'm understanding it. Is it the opposition? Is it that 50% needs to be of these CE hours from this group, but the other 50% isn't specified? So the other 50% can just be any fully licensed person that doesn't have to belong to an association. they'll just, so 50% can still be this way. Is it that they don't want any kind of a bracket around how much percentages can be from different groups? That's what
Yeah,
I'm trying to understand.
and that's a great question. I think that is correct. That is part of the concern. The example that I saw recently was, let's say I'm an independent licensee. I'm not a part of any organization or university, but I happen to be an expert in a specific topic, let's say self-harm, and I want to do a 2-day intensive seminar that's 16 hours of CEs. Now, you take my course, but you, as an LPC, you can only count 12 of those.
I see.
Even though you're taking all 16. And now my other 12 must come from one of these items on the list, which arguably there's a lot. But it is limiting, and it can be a challenge, I think, for some people, especially in rural counties, to find resources through the universities, through TCA, those organizations.
I would echo that. Dr. Taylor made a great example of my overall concern, and that was that, let's say there is somebody who is a subject matter expert on a very specific item, and they want to offer the 16 hours, and it's very popular. It is they are the expert. People want to go learn from them, but this, the way the rule is proposed, it does limit the CE hours that they could count for that year. And Dr. Taylor did a great job of explaining my concern about it.
Well, I have a question. What is the actual process for that? For you to become a CE provider, is there a specific process for LPCs to be able to do that? Is there a credentialing that that you go through for that to be able to and give that, or can anybody that's an LPC or LPC supervisor, let's say, be able to provide the CUs?
Right, anybody can. I mean, from the last sunset directive, when we went through the sunset process, they made it very clear that they wanted us to get out of the business of issuing CE licenses. So we dropped that rather quickly to comply with that. I believe the rest of the boards did as well. It's to some degree, anyways. So right now, anybody can roll into town and offer a CE. Which I understand invokes some anxiety and trepidation, but the other side of the argument too is, like, for me, my training is in existential psychotherapy. There is nobody in Dallas that can issue me CEs in that topic. I take most of my stuff online from London, where CE is the site of existential analysis. So most of that stuff wouldn't count under that 100% rule, which I'm okay with personally, but other people might not be, or might not be able to be.
Okay. So you're proposing then that we take this one off the table totally, take it back to Standardization Committee, rework that, and then come back with a totally new thing so that we can get the percentages better, or have no percentages at all, or it needs to be reworked. Is that what you guys are wanting? Good faces. Okay, so the answer is no.
It technically wouldn't go back to standardization. It would go back to the LPC board.
Yeah.
So go back to LPC board and then propose.
The Standardization Committee did its work when it came up with the standardized language and handed it off to the individual boards.
How did LMFT take this when you guys presented?
There was not, being dual licensed, there was not as much pushback from the LMFTs, but we also are required to do 30 hours, and LPCs are only required to do 24. So, most, like, if you're going to get EMDR trained, or you're going to do Tatkins work, or, you're going to do a specialty thing like you're talking about, we still can pretty much get all that in. But I understand what you're saying, and I think it's a real valid point that if half of your hours are 12 and the other half have to be, the other 12 have to be over here, then that does limit some longer term trainings. So I definitely can understand where you're coming from. Will that also be that you guys will go back to retweak? Because I know there were some other concerns as well with putting in cultural diversity, having that be as many hours. Kind of give me some feedback on what you guys heard with that too, because I saw some very negative points on that. So it's the beauty of being dual licensed, but I'm not speaking for the LPC board.
There were for, oh, sorry, go ahead, Chris.
No, you got it.
There were some, there was a little bit of feedback about the cultural diversity requirement, as in, is it necessary to specify this? It was not the bulk of the feedback we got, but there were a couple comments on it. I don't think that it has the degree of opposition that the limitations on the providers or the percentage on hours that count. I don't think that it has the same level of opposition.
Okay.
Dr. Taylor, would you agree?
I would agree. I think the larger shock came with the 0 to 3 hours. That we went from 0 and now it's 3, and we also added on 3 additional ethics. So I think people were looking at it saying, okay, I was only required to do, this. Now of my 24, 9 of the hours are already allocated that I must do. So I think that was more of the trepidation in that space. I don't think anybody was necessarily saying we shouldn't do it. I just think that the going from 0 to 3 was tough. Also, of course, anytime we come out to say, hey, this is now required, we're going to get pushback from other licensees that feel that something else should be required. I know somebody brought up trauma, that a lot of therapists don't have enough trauma training. We could argue that we should have, required couples or required family or, required med management, required.
Yeah, and
there's so much stuff.
to add on to that, there were some suggestions that some of the ethics subtopics should be required, specifically the ethics matters that get you in trouble with the board that should be required. I kind of see where they're coming from. Out of the ethics sub choices, I view it as, well, one of them carries a little more weight because that's the one, if you mess that up, you can get in trouble with the board. However, I'm reluctant without a kind of a consensus professional member opinion that we should even micromanage even further on our requirements. So but that's kind of my position. I see where they're coming from, but I am reluctant as a public member to start micromanaging the CE requirements of the LPCs.
Exactly, Stephen. We already have a fair amount of licensees that complain about difficulty finding Texas ethics CEs. As you know, we require specifically, Daryl, what is it? 3 hours in Texas, or it's 3 hours in ethics. How much is it in Texas ethics? 1 or 2? Do you recall?
Oh, I don't know. I'd be a liar if I said. Tim,
there's that specific hour that must be done, or maybe it's 2 or 3 hours that must be done, in relation to our ethics code. And I think people look at that and they get concerned of, where am I going to find this? And now let's say I can't make it to the big conference this year, so I'm not able to do that. But I really need to get my ethics, but it's taught by somebody who's not part of the 5 on the list. So I think people are worried about trying to do the right thing and then getting in trouble 2 years from now because they messed up their math somewhere along the way when they're just trying to get 24 CEs,
Yeah, when I'm taking a look at these rules, I look for what can we do that has a significant impact where we can show demonstrable improvement without just an onerous burden being imposed on what is already in place. That's how I look for it. And Dr. Taylor's right. At this point, we're starting to get into a lot of math questions like, okay, well, do I need to go back and review? Did this one count as was this an association or was this a independent stakeholder? So that's my way of saying that I did listen to the concerns in our written comments. It brought up some questions in my mind. Dr. Taylor, would you want to recommend that we just kind of pause this and send it back for additional board consideration?
I would like to point out, and I'll speak for myself, that I'm pretty bad at math as a therapist. Just FYI, I don't know about the rest of you, but math is not my strength. So the other thing I wanted to point out, though, is anytime we talk about supervision or continuing education, I think we have to be mindful of the fact that we are also talking about a component of people's businesses and livelihood. So when we start to regulate those, we are, hypothetically, if we were to discuss a cap on the number of associates a supervisor could have, we have to take into account that we're regulating somebody's business model. The same thing with the CEs, that we are regulating some of our licensees. This is the majority of what they do, right? Is they issue CEs, and so we do have to be mindful of that when we make these rules. So at this time, I think I'm in agreement with you, Cheryl, but I would like to move this back to the LPC board so we can table this, so we can figure out a more elegant solution moving forward. At least get more into the conversation and the discussion before we move forward with it.
So that sounds like a motion to kick it back to the LPC board.
That is correct. That is a motion to move.
Yeah, and I'll second that.
All right, so it's been moved.
61.140.
Yeah, thank you for stating that. Move to second and send it back to LPC board. All in favor signify by saying aye.
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 Opposed, say no. The ayes have it. All right, thank you very much. So we're sending that one back to the LPC board.
I will say, Mr. Chair, with that one going back to the LPC board, we really can't move forward on the remainder because it's a package deal.
Cool.
So they have to go back as well.
Do we need a motion to send all this back, or can we just leave them pending and wait for them to?
Or would they be tabled?
Wait for us to figure out what we're doing with our lives.
I think you can just table them, and if the board decides, I would just table them. Let's just let them sit there, and if we don't ever deal with them, it's not a problem.
Cool. We'll just lay them on the table.
I will add one thing, and this is not I don't want anybody to take this as a knock or a negative connotation, but I'm really throwing it out there to kind of as a way to manage expectations. Standardization Committee was set up to identify those areas where we thought we could achieve some commonality and some standardized language amongst the boards. We identified CE out of the gate as something we thought was going to be low-hanging fruit. I just need everybody to, and this is more to the public as well. I need everybody to understand we're trying, but as you can see, the professions view things very differently. And it's going to be a much more difficult task on more difficult subjects like supervision, those types of things. I mean, look, this is what we're encountering with just CE. Imagine when we start delving into supervision. I just trying to manage everybody's expectations here about, what we're looking at. So that's really all I had, Mr. Chair.
Sounds
I
good.
think that I also want to make a comment to that since I sit on that committee. I think that was a really good point, Daryl. And when we did this, it was not to handicap one license over the other. It's looking at what are the most commonalities between all four disciplines. Psychologists do 40 hours of CEUs, social workers and MFTs do 30, and then LPCs do just 24. And so the lower amount that you do, I get that the math makes it more difficult in how to put all those pieces in there. But that was what we were looking at, was all four disciplines across, and what are the most commonalities that we could possibly get. So it's not to try and make your world out there more difficult, but I get it. If you have a smaller amount than any other license does for their CEs, then how you carve it up may be a little bit more difficult.
And I would also like to remind the public that I don't want anybody viewing these types of actions when the council takes this type of an action as some sort of dysfunction. It is not. This is actually exactly what we're designed to do and exactly how we're supposed to work. It is not a dysfunction that a rule came from standardization to the LPC board only to hit the council, and then all of a sudden comments pop up that bring something to light. This is how the system works. This is how you get to a better place. Is it painful? Is it a little slow? Yes, that's the nature of government. It has to be that way because you move too quick. I mean, think about it. If we had moved too quick, we would have maybe glossed over some of these issues and would have gotten down the road. So I don't want people, we are not saying that this was a dysfunctional rule or a dysfunctional decision. I think everything happened the way it's supposed to happen here. I think everything is functioning the way it's supposed to happen. So just everybody keep that in mind, out in the public. We're not telegraphing a problem. The system is working to solve a problem here.
And to your point, Daryl, I think it's also really helpful that because we published it, that we got feedback from licensees that were not in agreement and pointed out some things that maybe we hadn't thought about. Maybe it didn't come up in the discussion. So getting feedback on these rules helps us to make it better. So I appreciate all of you that took the time to reach out to your individual board people, as well as to the council in general, your dislike on something so that we can make these adjustments. So I appreciate the public's interest and the public's feedback on this to help make it a better process.
Ditto.
I totally agree.
Yeah, Daryl, I appreciate you saying that. I like to say that I want the LPC board to make very deliberate decisions after thoughtful consideration on every time that we make a change, that we do something that we think is improving. And frankly, this process is designed to force you to make deliberate decisions. So the fact that this got sent up here today, and then we did receive the written comments, and I know Dr. Taylor, we read every single written comment, and I agree. This does mean that the system works. I wouldn't want to make a bad change. I would want to tweak it and make a good change.
Perfect. Well said by all. Okay, so are we moving on to 8B now? Is that correct?
Yes, sir.
So this has already been proposed. This is for adoption. The minutes, essentially that confirms that we're going to not keep, the minutes are going to be by audio, visual, and posted. Is that correct?
Correct. And the rule in 205, I've actually given y'all, when you look in your materials, you're actually going to see two different versions of that. You've got, one of them says 205, the other one says 205 staff recommended non-substantive changes. And let me tell you what that second rule does. Let me see if I can put them up on screen here so that folks out in the world can see what we're talking about here. Okay, the version on the left here is what was actually Patrick, correct me if I'm wrong, this is what was proposed, the version on the left here.
Correct.
And when you look at that, the length of it, even when you take out, the text that's stricken through here, it comes down, it'll be like 10 pages long, this rule will be. What staff did is, in order to shorten this thing if we can, instead of having like separate lines for 1, 2, 3, and then L5 over here, we just took and consolidated those lines into 1 through 3 if they were all the same level of punishment in order to save some room. We can consolidate what will be a 10-page document down into a 3-page document if we go with the version on the right, the staff recommended version. We don't change, there are no changes to the level of punishment. We just simply are trying to shrink this thing down. I think probably we can shrink it even some more. It's just Patrick and I didn't have time to work on it to get, the maximized shrinkage before the meeting. So you can go with either one, but if you want the shortest version that gets the same job done, the staff recommended version is the route I would recommend going.
Is there any discussion?
That is the version I would prefer as well. It definitely makes it easier to digest and find, and then also it reduces human error as well, because you don't have to update if you change a rule, we don't have to go change it 2 places. So
Yes.
It almost serves as a table of contents, almost to where you need to go. But is there a list like where you can look at what those individual, I mean, the same thing on a psych board, you know, same deal with the sanctions. Is there a place where you can go to see exactly what 681.52K is, you know, versus L or J, or where do you go to find that exactly? Just in case people in the public want to know.
Yeah, you'd have to actually go to the rule itself and look at the rule and see what that site refers to, the language
Okay.
of the rule.
Right.
Really, when you look at the schedule of sanctions, your target audience is the ALJ, agency staff, and the respondents in a case. Your licensees typically aren't going to go, well, I better check to see what that punishment level is before I decide to do this kind of this bad thing. That's just generally not how the thought process goes.
Right.
So that's why we opt for the chart method. It's very easy when you're in trial for the ALJ to go, oh, there it is. There's the recommended punishment.
All right, any other discussion? Hearing none, I will entertain a motion.
I so move that we approve B, item 1 and 2.
Second.
Are we doing item 2 with the recommended non-substantive changes?
Correct.
Shorter version. Okay, so it's been moved to approve 681.6 and 681.205 with the staff recommended non-substantive changes. All those in favor signify by saying aye.
Aye.
Any opposed, say no. The ayes have it. Thank you very much. And thanks to staff for making that shorter and easier and not creating more government paperwork where
Trying to save that paper budget.
that's right. Moving on to 9, reviewing consideration of like 781. 781 is a bunch of different subsections.
Okay, these are the social work rules. I mean, unless anybody has any questions, I'm not going to go over each individual rule. I know Chair Brumley isn't here today, but the most I can say, I don't know if Ms. Rogers, if you wanted to say anything on any of these rules, feel free to chime in. All these rules were vetted by the Social Work Rules Committee and the Social Work Board and are being sent up. Of course, 401 is the one that Mr. Francis spoke of earlier. That one of the big things these changes accomplish is they eliminate, we call it the 5-year moving window at the staff level. And it has operated, it's a change that really needs to happen because it's operating to hang up a lot of applicants. And it's one that everybody, when we looked at how it was operating and how it was affecting applicants, it's one that everybody felt like we needed to get that change made. So I think it's pretty important that we get those done. Now on 781.805, this is a similar situation to what we had up in the MFT rules. I think it was MFT we did that on, where they had already sent up one version of one set of changes on their schedule of sanctions. Now we want to pull that version down and substitute this version in its place. All the same changes will be made. It's just we don't want to wait for it to go all the way through the process. So it's a repeal and replace, and we are pulling down the previous version and substituting this one in its place.
So the motion would be to propose items 1, 2, 3, 4, the first 5, and repeal and replace 6. Is that right?
Yes, sir. And pull down the current proposed version and replace it with.
Right, in addition to.
Chair, I so move.
I second.
Been moved and seconded. All in favor signify by saying aye.
Aye.
Any opposed, say no.
Aye.
Thank you very much.
I'll make a motion to repeal and replace the schedule of sanctions 781.805.
I think did we just do that as part of that motion?
Separate, excuse me.
I believe we just took that action as part of the.
Yeah.
as part of the
My apologies. I thought we separated it out.
No, we could, but we actually took care of it in the first one. But thank you. There's nothing that we're gonna adopt. You guys let's go ahead, go around the horn on member boards reports. Anything that you'd like to report. We're gonna start with does anybody want to go first? About that?
I can go first, but our meeting's tomorrow, so I won't have a whole lot to say. So I really don't have much to say yet. Do you, John?
No,
We'll have more tomorrow, but
Janine, MFT.
Sure, I'm happy to do MFT. We met last week. Yeah. And I think the biggest thing that came out of it is that we're going to start looking at supervision. Some things are arising, especially with the telehealth piece. And do we have to do our 4 hours, 1 per week? Do we stack them in some way? How can we really begin to look at this? And so that's what we're going to be looking at. In addition, we also have had a couple of licensees. So this has caused us concern on our board. We've had a couple of licensees that were had their licenses revoked. And so now they have just hung up their, as is their right to do, and become coaches. Currently, coaching is not a regulated profession. You can become a coach just by hanging up your shingle, or you can do a small course that says you're a coach, but it's not licensed. So there's no protection for the public for any licensee that gets their license revoked because of misconduct, for a variety of things that you guys have already looked at that are in the schedule of sanctions. And so what we are looking at is, can we come up with something that we can put on our website or the BHEC website that kind of addresses why go to a licensed professional versus a coach that doesn't have any licensing, doesn't have any regulation. So we're going to start meeting to see if we can come up with some sort of language around that. But that's a big concern for us, just based on what we have seen happen in the last couple of years with licensees that lose their license. George, do you have anything you wanted to add? You're our numbers person.
No, number side looks good. I think you discussed the biggest one, which is people who turn in their license and go out on their own under the guise of coach. I think that is a real issue that we have to address and figure out. So thank you for that.
Perfect. LPC?
Well, I just wanted to ask a question real quick if I could, because I share your concerns, Jimmy. I think as we all do in our profession. Has there been any discussion on how this might relate to the Smile Direct issue via an antitrust or non-competitive sort of approach? Yeah.
No.
Because
No.
the last thing I'd want to see is us getting into a lawsuit like that. That would be terrible.
100%. And I'm not saying that people can't do it. I'm not trying to take away their ability, but some education around what are the benefits and what are the, what's a pro and con thing out there.
Right.
And if part of our duty is public protection, obviously I don't feel like, yes, once you make a mistake and you get a big scarlet letter and we take your license, where do you go now? What can you do? I don't want it to be where I'm, hounding them and following them around, throwing stones, or they go on some sort of list. But I think that maybe helping just for public education in what are licenses for, what's your recourse when something has happened and you have dealt with a licensed professional, what's your recourse? and what will your recourse be if you deal with a coach?
Yeah.
So it's really just an educational thing. I'm not advocating for the legislative body to take up any kind of rules around coaching. I'm just advocating that having it somewhere on the BHEC website or on the MFT website, since we're the ones talking about it, where would this be applicable? We have an outreach committee that we go and talk about the MFT license. Is this just something that the outreach committee talks about and it's not really published anywhere? But those are the things that have been coming up, and it's frustrating to watch it happen when you know the reason why the license was taken, and it's continuing to still happen under the guise of coaching. So it's super frustrating.
There's a gentleman that lives down the road from me whose license I revoked, and he is now a life coach, and it terrifies me.
Mm-hmm. Yeah.
I always like looking at what other agencies are doing, and as a commercial real estate broker, I'm thinking about the real estate commission right now, because there are certain things that an individual cannot do that are defined as these are practicing, holding yourself as a real estate broker. And there are sanctions if you do that. So there's really some pretty hard lines on what individuals can and can't do, and what constitutes real estate brokerage. And I'm gonna do some homework, because I know they have it, in terms of educating the public on what can just Jim Bob down the street do versus what can a broker do, or a salesperson. So if I can look at their like what they're doing to communicate with the public on that, perhaps we can be inspired by other people's work.
I would love that. Thanks, John. That'd be awesome, because I know that there are regular professions, just like you said, with real estate, with the law, what constitutes that when you start getting in trouble. And we don't currently have anything like that for us. So
and educating the public about the differences between, I don't see anything, Daryl, you stop me but I don't see anything that educating the public on the differences of what any licensee, what makes a licensee different. I don't see any issue in that. Now, the second we start getting closer to telling a life coach what they cannot do, to me, that's a wire that I think we should stay away from.
But on the other hand, if their license was revoked, like in Dr. Taylor's case he spoke of, they were probably doing something wrong, potentially even illegal. And then at what point does enforcement come in, and how is that enforced? So there's so many questions and ways of thinking about it that I think are all issues to keep in mind when we look at the broader picture of all of this.
Social work, Ms. Rogers, anything to report?
Nothing to report.
Okay, very good. Thank you. Didn't leave anybody off, did I?
Yeah, councilors.
Sorry, I say LPC. Sorry, go ahead.
No, that's okay. I'd like going last, because we've got actually pretty exciting news. During the roughly about a month ago, the 10th state adopted the Interstate Counseling Compact, which means that the Counseling Compact went into effect. And this was a very big deal. And it's something that Texas, there's not a lot of issues that 30,000 LPCs and tend to agree on, but from what I can tell, this is one of them. Texas LPCs would like for our state to join the Counseling Compact. It is such a big deal for our board that we created a new committee just to kind of manage the possible implementation. It's going to require legislative action, and so fingers crossed, this can be a productive partnership between stakeholders, between our legislative representatives, our individual LPCs, and the board. While we cannot advocate as a board for adoption, we can express our thumbs up in our individual capacity. And so this is a big deal for our board, and it's the main objective for the upcoming session. So that's exciting news. And the other thing I wanted to say is the LPC board hosted our first Insight insights over the lunch hour presentation. We did that last week. We had public member Vanessa Hall participate, along with Dr. Taylor and our board administrator, Christina DeLuna. They did a presentation on common scams that are targeting LPCs, how to avoid them, what to watch for. I kept a watch on the number of people attending, and we had over 130 people logged in for that. And we were excited. It was the first one of these, I think, that an individual board has sort of picked up and run with. And so really a special thanks to Dr. Taylor, who co-chaired it along with our, and I was excited because we had a lot of public member participation from Vanessa Hall, who put together the PowerPoint, who did a lot of the research, and it was fantastic. And we're going to try to do these more often. We were already kind of talking about doing another one in the fall.
Fantastic. Thank you for that update.
Dr. Taylor, anything to add?
There's one thing I would like to add, just as an update for the council. It seems that there is a growing, I don't want to say concern, that might be too strong a word, but conflict maybe between academics and the approval process as we sort of navigate what this looks like. Several years ago, we passed a rule change that allowed us to just view a degree as a counseling degree, and just say that we don't need to look at the transcripts, that it's good. And this helped us immensely with the backlog we had. I don't know if you remember the horror stories about 4 years ago. So people waiting, 18 months to get a job, right? Because they couldn't get through the applications process. So now there seems to be a growing discussion about how to apply that rule appropriately, what that looks like. Should we be going back to reviewing transcripts? What does academic integrity look like? What is our role in that process versus the credentialing body's roles in that process? So it's just kind of a conversation that has been growing. It's one that I imagine is probably going to continue to grow as most of our stakeholders are highly invested in academics. So I just wanted to put that on the radar as something that probably will be coming up more and more in the future.
Very good. Thank you very much. Any other additions? All right, we're buzzing right along. Recommendations for agenda items for the next council meeting. I'm going to start with this one. Something that I wanted to bring up and would love y'all to stew on it, the members of the public that are observing to stew on this as well. I recognize as a board, when we see an issue, it takes a lot sometimes for things to bubble up to the level that for us to see it. We've had instances, complaints, things have gone through ISCs where we've had complaints where somebody makes an allegation against the licensee, and it turns out to be, upon investigation, pretty bogus. And we've seen patterns. I've seen patterns both in ISCs and both in things on social media that people have sent to me about people coming to practitioners with different issues, sometimes sexual in nature, and it puts the practitioner in a very awkward position. And the question that's being asked is, I'm uncomfortable. At what point does abandonment come into play? And you've got these licensees that feel like they're kind of between a rock and a hard place. And we've put in rules about abandonment. We've sanctioned people, over things like that. But I don't know what the problem is. If we haven't communicated it well, if people are so gun shy that they feel like they have to continue in some of these things to get to even sometimes a dangerous position. I've had a couple off the record conversations with people who have experienced some of these things. And I think it's something from a board level. I don't know what the solution is. I don't know if it's a communication thing. I don't know if it rises to a rulemaking thing. But it seems to be that there is a perception among practitioners of where's the line of when can I just say I'm not comfortable with this person and where does their duty stop to refer them to somebody else if this person is being harassing or threatening? We've had instances of people, almost stalking and have, getting law enforcement involved. As a board, what is our role in communicating? What is that line? What is the safe haven for a practitioner? Because at no time should a practitioner feel threatened or feel like they need to continue with something and think that they're going to hear from us about, they've done something wrong because they were acting to protect themselves and their family. So I'm curious from fellow board members, from the public, is this something that you guys have seen or heard of? And what level does it rise for something for us to either talk about or communicate with our membership? That might, maybe if we put that on the agenda, maybe take and just make sure that people are aware that they can comment on it.
Okay, I'll make sure to put that topic on there and then we can open.
I don't know
it up
how
to
we word that
discussion.
exactly, but we can
Yeah.
talk about that. I just wanted to put that out there that this is something that I've had some conversations about. So when if this comes up on an agenda item, it wouldn't be the first time that anyone's been told about it or that it's something we're thinking about.
How about provider discernment for referring out best practice?
Yeah.
Because I think that's the challenge, right? Is when do I determine what is best for the client and referring them out versus abandonment? How to do that appropriately.
And balancing personal safety. I mean, that's the other thing. We've seen stuff. I mean, truly, like I've candidly wondered, like, am I going to read about this person in the paper? And we're just kind of handcuffed in a lot of ways of we just don't have the capabilities to do that much. So
I also think educating people on how to go about doing that, where they can find resources of what the next step would be, where to go to. I think that would be helpful as well.
Yeah, I'm sure ACA or APA have some best practice guidelines out there.
Exactly.
But I would not imagine we need to recreate the wheel here.
Yeah, I don't think it's a recreation of the wheel. I just, from conversations, it just seems like people are afraid of the board by coming down on them, and they're erring on the side of perhaps putting themselves at risk, the practitioner, and that's not what we're about. So I just want to make sure that we're communicating that clearly. If I've heard about it, I know that like I imagine it is more pervasive than we realize. Any other topics we need to put on the agenda for the future?
Chair John, just from earlier, maybe if we can come back with some ideas of how do we get rid of some of the manual processes and look at automation, and what can we do there, please?
Cool.
Thank you.
I would like to add an item, if I may, Mr. Chair.
Go ahead.
Discussion on what we're going to do moving forward as far as telehealth or meeting virtually, if we're going to have a hybrid setup, or if we're going to go all to in-person, or just stay Zoom. Personally, I'm happy to do either. The hybrids, though, are always difficult. I think it's a challenge just technologically, but I'm happy to be in person. I'm happy to go Zoom. I just wanted to keep that on the radar so we can start planning for that.
Yeah, I think that's a good agenda item for the next meeting for sure. I know a big part of why we're doing this now. I mean, part of it initially is obviously COVID. We actually have a real estate problem right now. How do we function in this room or in this building?
Yep.
I'm not sure if the insurance board was downstairs. They had the big board. It's just limited places for us to meet. Good call on putting that on the agenda there. Any others? Okay, so we are going to go. I tell you what, we've been going for a little bit. Let's take about a 7-ish minute break. I've got 12:21 on my clock here, maybe 9-minute break. Let's come back at 12:30, so in 9 minutes, whatever your clock says, add 9 to it.
Mr. Chair,
Yes.
did we not start with general public comments?
No, we did. We've got to go into executive session to take item. I forget the item. So we have that. We've been going for a little while. I want to give everybody a chance to catch a breath, restroom, water, and then we'll go back into executive session. But as far as the general business items of the agenda, Hang on, which one is it? Just so for
4E.
edification, we're gonna take up 4E in executive session and then come back and potentially take action. But everything else we've cleared off the agenda.
For the public's benefit, will we be dismissing out of executive session? Should they just leave now or should
Well,
they?
no, we'll come back into open session to adjourn, but we'll be in it will be, when we're back in session, we'll essentially come back into session. We may take action on that item and then we would adjourn.
I would, Mr. Chair, I would recommend rather than moving directly into closed session from this break, let's come back into open, then go into closed session.
Okay.
That way there's a date and timestamp mark of when we left
10-4.
open.
10-4. Okay, so we're gonna come back. We're gonna take about an 8-minute break now. Come back into open session here. Then we're gonna immediately go into closed session, deliberate, and then we'll come back after that to take any action and then adjourn. But the rest of the agenda is clear. All right. All right, we'll stand at ease for about 8 minutes. See you all in a few. All right, and we do have.
You got a quorum.
We got a quorum. Okay, perfect. All right, so it is 12:30 and the Texas Behavioral Health Executive Council is back in session. We're going to go into in closed session. So the Executive Council will go into executive session at this time pursuant to the Texas Open Meetings Act on agenda item number 4E. To deliberate the promotion of Director 4 to consider personnel matters under section 551.074 of the Government Code. The Government Code, the date is May 18th, 2022, and the time is 12:30 p.m. To all members of the public in attendance, you may stay logged into this Zoom meeting. The council members will leave, and once the council's closed session is finished, the council will rejoin this Zoom meeting. All members of the public that are in physical attendance are requested to leave the meeting room at this time, which there are none. Okay, Patrick, are you going to send out another Zoom link for us real quick? Is that correct?
Yeah, I'll email everyone a new Zoom invite to
Good
join.
deal. And I'm going to come down to your office and we'll go from there. All right, so to members of the council, get that link. Make sure you close out of this one and we'll see you there. And thank you to all the participation and members of the public today. If we don't see on the flip side of this, all the input was very appreciated. So thank you. Okay. The Executive Council has now reconvened in open session on May 18th, 2022, and the time is 2:07 p.m.
Chairman John,
Yes, sir.
I'd like to make a motion.
Okay.
I'd like to make a motion that we increase Executive Director Spinks's salary based upon the incredible work that he's done, the improvements that we've seen, the numbers that have come down, everything overall in terms of starting up this agency and running it. The fact that he hasn't received a raise since 2020, yet the work has continued. I'd like to propose that we come in at 165, which is a 38% increase over his current salary and highly exceeds the current marketplace. And by the way, I would associate the title of Executive Director 6, or excuse me, Director 6. So this will put him on the higher side of a Director 6 average of 163. He would be coming in higher than average. That would be the motion I put on the floor.
All right, y'all have heard the motion. Hearing no second,
Motion dies.
motion dies.
Chair, I have a motion for the floor.
Yes, ma'am.
Based on a brand new agency startup and the unknown responsibilities that went along with that, my proposal is to increase Director Spinks to Deputy Director 1 with an increase in salary to $175,000 a year, effective June 1st of 2022.
Chair, I'd like to second that motion and state that It is time that we recognize the value of mental health care in this state.
Heard the
I-
motion. Heard the second.
That was a clarification. That was 175, correct?
Correct, 175 with deputy, the level of deputy director 1, effective June the 1st, 2022.
Thank you.
I would open the floor that as much as I would like to say that it recognizes the value of mental health, I think it recognizes the work that Daryl has done. And as much as I would like it to recognize the value of mental health and people put more importance on it, I think the money is placed in the right person. And I think we want to do everything to keep Daryl. Daryl, I just need you to know, I think you're doing great. I don't think it's fiduciary responsible based upon the discussions to be able to do that, or that we should do that. But I am in agreement that the work, everything that you've done, as you heard from my initial motion, is very good. So I appreciate you.
Any further discussion? Hearing none, all those in favor of taking Mr. Spinks to Deputy Director 1 and 175 effective June 1, signify by saying aye.
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 Opposed, say no.
No.
One opposition. Motion carries. Daryl Spinks, thank you very much for your service and for the job that you
Very
do.
much.
Appreciate you very much and appreciate the very deliberate discussion from the board in arriving at this solution. The
Chair,
agenda-
I would just like to say sincerely thank you on behalf of me and my family.
Yeah, we appreciate you, and you're very talented, and hope we keep you for a very long time. I think that for what this agency has done in this new model that, of bringing all of the mental health professions under one roof, it's a new concept. I think other states are taking notice. Proud of what we're doing here. I'm proud of you and very much proud of the staff as well. They're a reflection on you as well.
Thank you, Daryl. You earned it for sure.
All right, without objection, I'm going to adjourn the meeting. Anyone object? Hearing none, this meeting is adjourned. See you next time.
Ciao.
Thank you all.
Thanks, everybody.